Mediation is a really positive process. It's used for resolving disputes between parties who want to talk with each other in a structured, facilitated environment, but can't do that themselves and also don't want to litigate. So in mediation, there is a mediator who facilitates the discussions between the parties, but they don't impose a decision on the parties. They don't make suggestions usually for the parties how they would resolve the dispute. But they do help the parties talk together. They will summarise what the parties are saying, they'll use questioning as a particular tool, and they'll do a thing which is reframing. Reframing is where they'll take what a party has said and take the toxic nature out of it and help frame it in a way that might move the parties forward with their disputes. Understanding why the dispute is going on and understanding what the positions of each of the parties is and why they feel the way they do is important to coming to a resolution. Mediation is particularly relevant for disputes where there's a lot of emotional content to the issues. There might not be very much financial value attached to the items in dispute. For example, it might be a ring or some possessions of someone who's died, but there may be a lot of emotional value attached to those things. So the best thing for parties to do to prepare is to really think through the issues that are in dispute, to think about what they'd like to be an outcome of the dispute, and to think about a range of options that might suit them. It's quite a structured process and it generally follows the same sorts of steps. Each party will be asked in turn by the mediator to give a very brief statement about what the main issues in dispute for them are and what their main concerns are. Usually after that, the mediator will summarise each party's concerns, which is an important part of the process in trying to clarify what you're saying and what you're thinking. The next step of the process is to set an agenda, and the mediator does that. The mediator will often take the parties into a private session individually. So that is the confidential session where the parties talk one-on-one with the mediator. Generally, that's an opportunity to explore how you're going in the mediation session and whether there's anything that you need to say to the mediator that you can't say while the other party is there. Once those private sessions have finished, then generally the mediator will bring everyone back together, and everybody usually is at a point then where they can move forward with the negotiations and really settle on some of the options for resolution that are the best options and come up with an agreement together. So if the parties do want to make it legally binding, they need to take it to their lawyer. Mediation is an unregulated profession, so when parties are looking for a mediator, they need to be careful about the fact that the person that they go to is a qualified practitioner who has training in the process. Many lawyers are mediators, and you can access them through law societies in capital cities of all the states. Attorney General departments of most state governments have dispute resolution centres or some sort of mediation service provider, which is a good point of contact, particularly for disputes about wills and estates. Mediation isn't an appropriate dispute resolution process for every dispute about wills and estates, but generally when people come to mediation, they've agreed at least to some level that they want to resolve the issues themselves without going to court. The agreement rates for mediation are quite high, and they sort of reflect that fact that parties actually do want to work these things out together when they come to the process. In the dispute resolution centres of the Department of Justice of Queensland, Attorney General's Department, the success rate is about 89% for matters that come to that department. That means that in 89% of matters, generally some level of agreement is reached. It might be a partial agreement or it might be a full agreement, but at least the parties are assisted in coming to some sort of agreement of the issues.